Hi, everyone. Good morning, good afternoon, good evening, depending where you're joining us from. This is the Mission Mediation podcast brought to you by The Pact. I'm Jonathan. I'm a mediator and founder of The Pact. And once again, a huge welcome to everyone joining us live on a sunny Sunday in LA, where the sun has just risen, where Jeff Kitchewin is joining us from, and the sun has set a long time ago in Delhi, where Nishant's joining us from. And yet we're having this fantastic podcast talking about mediation. So wherever you are joining us from, drop a hello in the LinkedIn comments. Tell us what's exciting in your world of mediation. This is going to be a very fast-paced, but once again, a very interesting conversation between two mediators discussing that commercial mediation, private commercial mediation actually works, right? And that's the whole focus about this podcast. It's going to be very, very uh, focused in terms of understanding the nuances and the dynamics that a private commercial mediator takes into account while designing and executing and, at the end of the day, facilitating a commercial mediation. So drop your questions, use the comment section on LinkedIn, and you can always agree and disagree with what Jeff and Nishant are speaking about. You don't have to just simply nod your head and say yes to them. You can, of course, disagree and ask them questions and have your opinions being heard as well. If you are if you have just joined and this is your first ever experience on the Mission Mediation podcast, we have 5 more episodes, all archived on our YouTube channel and also on our LinkedIn handle. So please go and have a look at them. Some fantastic conversations that we have had on both mediation and mediation advocacy, where we spoke about the role of a lawyer in mediation. But most of you know Jeff Kitchewin, isn't it? I mean, Jeff Kitchewin is someone who we all relate to because his posts on LinkedIn are so relatable. He talks from the heart as a mediator and once again really draws in the clients, draws in people to mediation in a way that no one else does. But he's an independent mediator in business disputes in international space, both in functioning in the online and in the in-person space. His specialties lie in, of course, insurance coverage, and bad faith negotiations. He also does a lot of mediations in the intellectual property space, information technology, and also in the entertainment space. So Jeff brings in a lot of experience, over 3 to 4 decades of experience as a mediator. Of course, he also does a lot of mediations in professional liability with his legal and accounting malpractice. So we're going to dive into some of these case studies today with Jeff, and Nishant's going to lead us to that. For those of you who don't know Nishant, he is, of course, a mediator based in India. Currently, both of us are coming to you live from Delhi, whereas Jeff's in the LA. Nishant, of course, is a trained mediator both with the IIM and IIC, and of course now with the National Legal Service Authority. Nishant brings in, of course, a rich experience as also an in-house counsel, where he served as a mediation counsel on many matters with the organization he worked at. Nishant's, of course, very, very passionate about mediation, and both of us have taken this journey to really highlight the role of a lawyer in mediation in the last so many years. And of course, Nishant has had the privilege of working with over 15,000 young lawyers and orienting them in terms and training them in terms of their role as a mediation lawyer. So you're up for an exciting session. I'm going to pop in the back end and I'll be with all of you as the audience, whereas Jeff and Nishant take center stage today. Jeff, Nishant, the stage is yours. Have fun.
Thank you so much, Jonathan. Thank you. Thank you all for joining in. I've been wanting to have this conversation with Jeff for almost a year now. It's all the time we're seeing his LinkedIn posts, which as Jonathan said are very, very relatable, very practical, and I have actually shown them to a lot of my own clients to help them understand the essence of mediation. But today, I want to. I'm here, with Jeff to pick one of his recent mediations and try to break it down and understand the aspect of his preparation and process design. That is what is going to be my focus for the day. Jeff, how are we doing? And thank you for joining us. I would love for you to share the case study, the wonderful case study that we were discussing about, so that then we can begin our round of quick fire questions.
Okay, well, first, Nishan, thank you so much for having me on your podcast. I'm a great admirer as well as a great supporter of what you and Jonathan and the others have done at the Pact. First came over to India at the end of 2018, I think it was, to be a judge in the Advocate Maximus competition. And ultimately, I've been to India 3 times to visit you. Last time, most joyously, for your wedding, a little over a year ago. And of course, I took that opportunity to add to my collection of trunk-up elephants. You can see 2 of them behind me. Those 2 models are from Cochin, when we went down to Kerala after we were in New Delhi for your wedding just last year. So, Nishan, do you have a share screen, or how do you want to talk about the hypothetical?
No, so you can just share as to what the facts are. So let's do this. Let's first share with our viewers the facts of the case. Now, viewers, of course, because mediation being a confidential process, there is a bit of confidentiality that needs to be maintained. So, of course, the names of parties and other confidential details will be changed, but the essence will remain the same. So, Jeff, yes, if you wish to share screen, you can
I'll
present the screen. There's an option to present at the bottom, or you can narrate the
Yeah,
facts.
we can share the screen. Let me
There's a
see how we do it on
there's a
this
present
particular
sign on the bottom. There's a square
present.
box.
Okay,
Yes.
we've got present, share screen, and let's see if I can see window and well, I don't see it coming up. Why don't I just read it, Nishant, in the interest of time?
Okay.
Okay, so let me pop it up onto my screen. Okay, Delico is a high-tech startup making diagnostic tools for other technology companies. It needed to build a prototype tool for a potential new customer and ordered certain components from Mumbai Manufacturing. The purchase order from Delico included a deadline for delivery. Mumbai Manufacturing missed the deadline. Delico was not able to produce the prototype. The new customer gave the business to one of Delico's competitors instead, which profited richly from the account. Delico is owned by 3 young, smart entrepreneurs with both business and technical educations. While they are as bright as can be, they are young, impulsive, and have never been in litigation or a serious business dispute before. Their lawyer is a senior litigation partner in a firm where another partner is the uncle of one of the entrepreneurs. And these 3 young entrepreneurs, they thought this would be their big, huge break. Mumbai Manufacturing is a big company. It's been in business forever, and it's represented by a big law firm which has represented the company forever. There's some evidence, though nothing conclusive in writing, that Mumbai Manufacturing knew of the specialized need for the components and that Delico stood to make huge profits from the contemplated contract with its new customer. There's also some possibility, though one never knows for sure, that these 2 companies, Delico and Mumbai Manufacturing, could do business in the future. So that's our scenario.
Okay. So I do understand that in this case that you mediated, again, to remind our viewers that the names, of course, of parties have been changed. So in this case, Jeff, if what I have understood, that there is one company that is a high-tech startup making diagnostic tools. It had to create a prototype for which it had certain components, for which it required certain components, and went to another manufacturing company to get that manufactured. they missed the deadline, because of which there were certain losses that the first party incurred, and now they are here in a mediation before you. Have I got that correct?
You've got it.
Okay, so that's an interesting case, Jeff. I would first, and the first thing I'd like to know from you on this case is, when this case came to you, when this matter came to you, even before the mediation started, what was your process like in run up to the mediation? What did you do in this case? What do you generally do? How do you prepare for something like this?
So, Nishant, first of all, let me first say I'm happy to discuss all these things. This is really a composite of a few different cases because of the confidentiality concerns that we have in mediation. I can't actually make it just one specific case because at least the parties involved might recognize it and they would not appreciate that without their permission. So let's talk about it as in the composite sense, because the structure and process of the mediation is really what interests you, and I think interests our viewers here. And it's important to remember that it's the structure and the process that gets imported or superimposed, if you will, on any mediation you have. And of course, the structure and process has to be adapted for the particular people and the particular situation involved. Yet there is a structure and there is a process, and that's what makes it possible for us to teach this to other people, that it's not just a hunch, it's not the seat of your pants, it's not just, well, let's try this. Although there are elements of risk-taking and experimentation in every mediation, there's a structure and a process to it. It's also important to remember that the mediations come to me, by and large, voluntarily. They're not, occasionally people are ordered by courts, but if a case here in the United States, if a case is ordered by a court, you already start out at somewhat of a disadvantage, because in the United States by now, sophisticated lawyers have been involved in many mediations. Clients who are interested in cost savings and early resolutions in commercial contexts are pulling their lawyers into mediation. And court systems, which are overloaded and want to get civil cases resolved so that they can devote resources to criminal cases, matters of public safety, matters of child welfare, and other things, courts are pushing people out into the mediation process. But nonetheless, although courts do sometimes order people, by and large, it is voluntary, because lawyers, once they've been through a mediation process a few times, recognize the tremendous benefits of the mediation. We exchange a tremendous amount of information, and we do it efficiently. We allow lawyers to work collaboratively with their own clients, shoulder to shoulder, arm in arm, so that decision-making is a collaborative process between lawyers and their clients. The collaborative process between lawyers and their clients tends to cement the attorney-client relationship and create tremendous loyalty of the clients to the lawyers. The clients get to see their lawyers in action, work collaboratively, work respectfully. And so, yes, a case does get resolved. And in that one case, it may work to the economic disadvantage of the lawyer to get the case resolved faster rather than more slowly. But the long-term benefits to the lawyers are tremendous, because when you have a more satisfied client, what do those clients do, Nishant? Well, for one thing, they pay their bills. For another thing, they come back with more cases. And for a third thing, they refer their friends and colleagues, people from other companies. So by producing a more efficient result in one case, the lawyers find tremendous benefits on the long-term horizon. And I think that ultimately explains a lot of what has fueled the growth of mediation in the United States and the United Kingdom and Australia, New Zealand, Canada, and many other countries as well. So with that said, the first thing that I do is I say a prayer of thanks every time the phone rings or an email comes in and it's a new case. Because as a mediator, we lead this sort of itinerant lifestyle. We have cases for a day or two at a time. That's how long a typical mediation lasts. And nobody has a contract with us to bring us more mediations. So anytime a case settles, that's great for the mediator. And then you wake up the next morning and you say, well, I need another case to take its place in the pipeline. So every time someone calls, I'm just so thankful. And life as a mediator in the United States requires a constant effort to keep in front of the lawyers who hire us. And you mentioned my presence on social media and LinkedIn. That's certainly part of it. And also in-person events, conferences, bar association events, publishing articles in newspapers, a little paid advertising. So it's first thing I do is I'm just in a state of delight and rapture every time somebody hires me. And then it's a matter of getting down to business. So the first thing that I do, Nishant, is I send out the confirming materials. People have to decide, are we going to mediate online? Are we going to mediate in person? If we're going to be in person, are we going to be in my office? Are we going to be in one of their offices? If the case is online, we sometimes have a serious debate over what time to start. Last couple of weeks ago, I did a mediation. It was a patent law case. And in patent law cases, we often have lawyers in the United States, but the principals are all over the world. Well, in this case, we had one set of clients in Taiwan and one set of clients in India. And the lawyers were all in the United States, but sprinkled in different time zones around the United States. So I said, sort of regret it now, but I said, well, we can start at whatever time you all want. So they decided to start at 6:30 in the evening, California time, which was the least inconvenient time on average for everybody. And we ended up, California time, we ended the mediation at 5:45 in the morning. So that was a long night. So, but even the matter
that you end up doing post, once we get the matters, you send out the confirming materials to confirm the logistics of the session. Right. Okay.
Right.
And then
and we set a schedule for briefing. And because the cases on which I work tend to be rather complex, I like to get the briefs a week to 2 weeks before the mediation. That way,
what do you expect in these briefs?
Nishant, I don't put a lot of requirements on the briefs. I would say in general, you want to say, first of all, you want to tell the mediator who you represent. There are times when I get mediation briefs and they start with these rambling recitations of facts, and I get to page 4, page 5 of the brief, and I say to myself, does this lawyer represent the plaintiff or the defendant? That's not a good mediation brief. So right up front, say, we represent plaintiff Delico or defendant Mumbai Manufacturing in this breach of contract dispute.
Right.
Okay, you represent the plaintiff, it's a breach of contract dispute. Then it's generally a good idea to have a recitation of what the facts are. And as mediator, I know that the facts are, you're putting them in the terms most favorable to your client. Right. And I know that I have to I have to refrain from making too many judgments before I read everybody's brief. But I do like to read the briefs all at once. So I generally wait until the last brief comes in before I start reading any of them.
Okay.
So then the recitation of facts. Then generally people will say why they think they're going to win. And people talk about not only their own the strengths of their own case, but as you would in a trial brief to a court, you try to anticipate and preempt some of the arguments that the other side is going to make. So in this case, for example, if you were representing Delico, you would want to have something in there about whether you can recover consequential damages, whether you have a shot at recovering the profits you anticipated from the deal with your customer. And as a result of Mumbai Manufacturing not fulfilling its contract, you couldn't put together the prototype. You have to have something in there about why this is not just a claim for speculative damages, why you can actually collect consequential damages and they're not speculative in this case. Then the next thing that many people put in is the procedural posture of the case. Has a lawsuit yet been filed? If a lawsuit has been filed, what has happened? Have there been motions to dismiss? How much discovery has taken place? Have people exchanged expert reports? When is the trial date? How many depositions are yet to go? Have the key witnesses been deposed? This sort of thing. So you get a sense of where the litigation stands in its life cycle.
Okay.
And then the last thing that a lot of people put in is the history of settlement negotiations. Have there been previous settlement negotiations? Has there been a previous mediation? A lot of cases that I get, Nishant, there has been a previous mediation which has not succeeded. And many times I'm the second or third or even the fourth mediator to work on a case. And I take particular pride in getting those cases settled. So it is amazing how often people do not agree on what was the last offer and what was the last demand, particularly if there has been a previous mediation, and particularly if the mediator engages in a shuttle diplomacy only approach where there's no direct communication between the parties. Because when the mediator is shuttling back and forth, the mediator may say things like, well, ultimately I think I could get Delico to accept this. Or ultimately, I think I could get Mumbai Manufacturing to pay this much to settle the case. Well, the mediator may be engaging in speculation, but the parties many times hear that as if they were actual offers and demands. And they were hints, they were speculation by a previous mediator, or lawyers in conversation between them might say, I think I could get my client up into this range or that range. It's not intended as a concrete offer.
This is all in the history of settlement that you share. Okay.
Yes, all in the history of settlement. So sometimes, Nishant, my work before the mediation or at the beginning of the mediation day, is just to get people to agree on what is the starting line. What did you offer before? What did you demand before? Make sure we're on common ground with respect to that. So those are the things that you generally see in a mediation brief, in a good one. Now, they're not all. Nishant, let me just say, some mediators are very directive about how long they want the mediation brief to be, what exactly they want covered in it. I don't put requirements like that on people because I want to get a sense of what kind of lawyers I'm dealing with in a particular case. And if the lawyer writes a 50-page rambling brief that goes nowhere, that's actually quite helpful information to have about the lawyer with whom I'm dealing. You know what I mean?
Yeah.
So, So challenges come to mediators from every direction. So once I get the briefs, I like to have conversations with the lawyers before the day of the mediation, separately with the plaintiff side and with the defense side lawyers. And those conversations, Nishant, they generally take 15 to 30 minutes. That's some of the most valuable, most important time in the whole mediation, because there's always more to the story. I live in Hollywood, Nishant, and here's we say, what's the backstory of the main story of the script? And when I
Yeah.
get the lawyers on the phone or on one of the video platforms, wow, do I find out what the lawsuit is really about? And I try to ask open-ended questions in those phone calls. Questions like, what are the challenges we face in this mediation? What are your expectations of me in the mediation? Because the answers to those two questions, the challenges might be very different, and people's expectations of me might be very different going from case to case. I
Hmm.
like to ask people about the personalities. Tell me about the personalities of the people involved. Because for example, in this case, if Delico is owned by three young entrepreneurs, right? And we might hypothetically call them Nishant and Jonathan and some of your other partners from the pact. Well, you all, the three entrepreneurs probably have very different personalities, and
Right.
they might have, almost by definition, one is going to be more hawkish about the dispute, one is going to be more dovish. Those are terms that we would use in the United States. I don't know if you would use those terms in India, but if you don't, let's say one might be very aggressive about how to pursue this claim. One partner might be very conciliatory and eager to put it behind them quickly, and somebody might be in the middle. So this lawyer for Delico has his or her own challenges in balancing
Sure.
the desires of three owners of the company.
And
Well,
personalities as well. Like it
yes,
becomes not only what they want, but their thought processes as well as to how to achieve what they actually want.
entirely, entirely. And so finding out from the lawyer for Delico what are the issues as between him and his own three clients. And if a mediator is lucky, a lawyer will start talking about these personality issues. I will ask a lawyer if it doesn't come up, if it hasn't come up yet, I'll say, tell me about your clients. Tell me about their personalities. Tell me about how the nature of the attorney-client relationship. Is it strong? Is it new? Is it well established? And this is a difficult thing for many lawyers to discuss. Lawyers are not accustomed or trained to discuss these personality issues, these softer issues, as well as they're trained to talk about the strengths and weaknesses of legal claims and defenses. But yet, this is often the most important stuff for a mediator to know, because the real reason that a case has not settled yet may be because one of the clients is very angry, taking it personally, wants revenge on the party on the other side. There may be a real grudge match going on. And if that's what we really need to address in the mediation, the personality issues, the emotional issues, it's very helpful for the mediator to know about those things in advance. And then, Nishant, in those preliminary calls, we'll also talk about how we're going to begin the mediation day, and
Okay.
specifically whether we need an opening joint session or not. And in the United States, mediators are by and large trained that it's a good idea to have an opening joint session where people talk about whatever's on their mind
Hmm.
and use that session to form the agenda for the mediation.
Right.
And in the United States, lawyers have largely rejected that. And mediators keep pushing for it. But at least in that open-ended plenary format, lawyers have rejected it. Because what happened? Mediators would go turn to lawyers in each other's presence. Tell me about the case. And lawyers would launch into a vigorous, sometimes inflammatory, sometimes personal attack on the other side.
Right.
They would do this to satisfy their own clients who wanted to hear their lawyers be, the super champion of the case.
Okay.
And it might satisfy a lawyer's own client, but it would sure antagonize the other side. And it would throw the mediation off the tracks, sometimes impossible to get it back on the tracks. So lawyers simply refuse to participate in that sort of opening joint session. And then we got to a point where most mediations, or many mediations, would never have the parties talking to each other, that it would all just be shuttle diplomacy with the mediator going back and forth between Mumbai Manufacturing at one end of the hallway and Delhi Co. at the other end of the hallway. And
so Jeff,
in
here,
my,
when you're dealing with the lawyers,
yes,
is the fee or the mediator's fee? How is that put across to them? Is this something that's pre-decided, or you deciding? And how does that happen with them, or is it that that's something that you share with the parties?
sorry, Nishant, it got a little garbled. What were you asking about, the mediation fee?
Yes. So how is it that, before the start of the mediation, when is it that you inform them of the fee as well? Is this prior to this 15 to 30-minute conversation that they have, or is it during this time?
Yes, the fee is posted on my website.
Okay.
And when people say, call me or email me, Jeff, we want to have mediation, great. We pick a date. We figure out whether it's going to be online or in person. If it's in person, where. Then I send them out a confirming letter, and I send them out the invoices, because I bill by the full day, and the fee is for an 8-hour day. And people deposit that fee. I require people to deposit that fee before the mediation starts.
Okay. Fair.
And if then that covers 8 hours, reasonable prep time, 8 hours of running time on the mediation day, and reasonable follow-up if necessary, because a lot of cases don't settle on the first day of mediation, have to follow up. So, for brief phone calls or emails afterwards, I don't charge extra for those. No nickel and dime billing.
No.
So by the time we get to these phone calls, people have received their invoices and know that they have to post the mediation fee before the scheduled day of the mediation.
Okay. So if I understood,
it's very important, Nishant, to have some game plan before the mediation day. Are we going to have a joint session or not? And I find that lawyers are more open to having a joint session if it's not just a plenary discussion of the issues, but if we've had some collaborative effort between the mediator and the lawyers as to what is really the key issue here. What is really keeping people apart? Is it a measure of damages? Is it a liability issue? Is it a collectability issue? Is it an evidentiary issue? Is it a legal issue? What is it? And if we can agree and diagnose, what's really keeping people apart is what is the appropriate measure of damages? That's an issue I like, because it doesn't really implicate the party's conduct. It's a legal matter, benefit of the bargain, out of pocket, consequential, it's a law question. So let's say in this case, we realize that the key issue is, can Delhi Co. recover the consequential damages, the anticipated lost profits from the deal with its prospective customer that went to someone else instead of Delhi Co. because Mumbai Manufacturing did not provide the component? That's a nice issue to discuss in a joint session, as I say, because it's law stuff. A bad issue to discuss in the joint session would be, for example, did Mumbai Manufacturing intentionally sabotage Delhi Co. by delivering the product late because it was in league with one of Delico's competitors, or somebody at Mumbai had an argument or a grudge against one of the three entrepreneurs at Delico. If it gets into personal stuff and whether someone is evil or not, that is a difficult issue to discuss in each other's presence. That's a very personal thing. So if we can find a clinical antiseptic sort of issue to discuss, and measure of damages is a good candidate for that, I might say to the lawyers, look, what's keeping you guys apart is this measure of damages question. Maybe we can have a joint session just limited to that. And we'll agree that it won't take longer than 30 minutes. And you all will limit yourself to this one issue. And if it looks like things are getting emotionally agitated or out of control, just look at me, make a funny face at me, and I'll know what that means. And I'll put a stop to it, or I'll intervene somehow to make sure that the emotional conversation does not get out of control. And then, Nishant, then we can have a joint session that is productive, it's constructive, and we minimize, if not completely eliminate, the risk that it's going to be so inflammatory that it throws the mediation off track.
So, Jeff, I'm going to
And
come here and pose a small question to you. So, I
sure,
do understand in your process, you said that when you do get a case, you look into the briefing, you schedule a briefing where brief from both the parties come in, and then a day or two prior the first session of the mediation, you'd like to have a call with the lawyers, 15 to 30 minutes. Do you also have a call with the parties, or do you have a separate call with the parties to prep them, or is it or do you speak to them directly on the first day of the mediation?
it's uncommon, Nishant, to have the clients in on those conversations. Sometimes a lawyer will say, my client would like to be in on the preliminary call, and they're always welcome to be. And it happens infrequently. The first
Okay.
time I see the clients is generally on the day of the mediation. And what I'll generally do on the day of the mediation is, before we have the joint session, before the mediation quote unquote begins, although really the mediation began the first time they inquired of me about scheduling a date. But when they come to the office, or if we're online, I'll put them into a breakout room or conference room in person. And I'll want to talk to the lawyer and the client in the lawyer's presence, of course. And I'll say to the client something like, I don't know how many mediations you've been in. Maybe you've been in a lot. Every mediator does things differently. Do you have any questions about what we're doing today? And many times the client will say, no, not really. And then if you allow a moment of silence to exist in the room, the client will say, oh, well, wait, there is this one thing. And the client will have some questions about what we're doing. And it's a good opportunity for the mediator to develop some chemistry and some rapport with the client, answer their questions, make sure that they're not agitated. We want them to be at ease as much as possible. The mediation process, there's some tension that's inherent in the process because people are in conflict. We don't want it to be any more tense or stressful than it has to be, because additional tension and stress makes it harder for the clients to make good, strong decisions. We want them to make good, strong decisions. And it's a good idea, I think, for mediators to develop a little chemistry and a little rapport with the client at the beginning of the mediation day, because at the end of the mediation day, in so many cases, the lawyer is going to come to the mediator and say, look, I know it's a little more than my client really wants to pay, or a little less than my client really wants to take, but it's still a pretty good deal. It's a good settlement. It's not great, but for settlement, it's a good settlement, and the client should put it behind them on these terms. Please help me get my client to do the right thing and put this litigation behind them. They pay a little more, they take a little less, but they get the darn thing over with. They stop paying my fees. They get to go back to their lives, their family, their careers, their businesses. If the mediator has taken a little time at the beginning of the day to establish that rapport and chemistry with the clients, the underlying clients, it can pay off big time at the end of the day when the clients have the trust and affection for the mediator that allows the mediator to be effective in helping the client overcome the overly emotional responses and do what makes sense logically.
Okay, so then I'm going to be jumping. So I've understood the from the start process to the first session, and that'll bring you to my last question. Since we're focusing on the preparation before the first session begins, and my last question would be, Jeff, now that you've got this information, you went through the briefings of both the parties, you've had this conversation with the lawyers before mediation day, separately for 15 to 30 minutes. You ask them questions regarding what challenges are there, what are the expectations from you as the mediator. You ask them about the personalities of the parties involved, and how they would like to begin the mediation day. Now, with all this information, how does Jeff Kitchevin, the mediator, personally prepare? What does he do with all this information before he starts the in person or the online session? Or is it that you completely store that information at the back and go completely new to gather more information directly from the parties?
Well, this is what I do, Nishant. This is how I assimilate all of that information. And remember, what I'm interested in is structure and process. I'm not trying to be, I always enter mediation as the least knowledgeable person about the dispute. And I remain the least knowledgeable person. So my job is to create the structure and environment where lawyers can do the best job possible of negotiating for and representing their clients, and clients can do the best job they can do of making strong decisions, clear, strong decisions in a calm, informed environment. That's the real goal of the mediation. And if we set it up that way, then cases are going to settle. Cases settle all the time because the mediator does not try to take over the lawyer's role, doesn't try to bully or badger or berate or belittle the client. Everybody's got their role. And the right settlement becomes obvious. It becomes obvious when people are working in tandem this way. So there's no need for heavy-handedness. There's no need for bullying. There's no need for threats or anything like that. The right settlement becomes obvious.
So it's the process that helps reach the right settlement. Jeff, it was a pleasure speaking with you. All mediators have different processes to prepare for their mediation. And of what I have understood in your case is that there's a lot of information gathering before you finally go in for the mediation, which is wonderful to know. And yes, I would love to dwell more into case studies where we can talk about what happens in the joint sessions, how to use a private caucus, how to close the day. But we will definitely keep another podcast session that's focused only on that, how to use the mediators, how to use the lawyers. There's so much more that we can dwell in, but we will definitely keep on another day just to avoid information overload. And we will be back with you for another episode focusing on another stage of mediation. So thank you for joining us early in the morning.
Nishant, thank you, Nishant. It's a pleasure to be here collaborating with you and Jonathan. I hope this is helpful to the audience. If anybody would like to connect with me on LinkedIn, that's great. If anybody has any questions, they could welcome to send me an email. My email is my initials, JK, at my name, jeffkitchaven.com, and you're welcome to put that in the chat or whatever function it is that communicates with our audience. And again, send me a LinkedIn invite. I love the legal and mediation communities of India I can't wait to come back to India to see you guys in person again. And you're doing so much to generate support, to generate growth in interest in and use of mediation in India. I admire what you do, and I compliment you and just acknowledge you for it from sun up to sundown. It's awesome. Thank you for having me.
Thank you so much, Jeff. Thank you so much.